The civil rights organizations of the left have now agreed that racism is okay and discrimination is okay. They've abandoned the field. So it's up to groups like Judicial Watch to take the lead to enforce the traditional understanding and interpretation of the Constitution and civil rights laws. So we filed an important on moving to the issue of elections. We still got a lot of election cases going, you know that? We've got cases in California, Illinois, Oregon, Mississippi to clean up the voter rolls, to vindicate the rule of law that you can't count ballots that arrive after Election Day. As I've previously noted, our work in this area has cleaned up just in the last few years 4 million names from the voter rolls. Colorado, Pennsylvania, D.C., New York City, California, Kentucky, North Carolina. I'm sure I'm missing a few, but huge. But there's another area of law that we've been involved in, which is the issue of gerrymandering. And what is gerrymandering? It's funny, I was writing or editing our release, and we used the word gerrymander, and I thought, you know, I wonder if people know what that literally means. I mean, we use it a lot here in D.C., and gerrymandering, so for those of you who don't know exactly what it means, you may have heard the phrase, but what does it really mean? It means basically when it comes time to figure out what congressional districts look like, they move people around and create districts that look ridiculous in order to guarantee certain results. So, and both parties do this to a certain extent. We had a big case in Maryland, for instance, where they had a political gerrymander to guarantee that the Republicans would only win in one district, I think. And we weren't looking for a specific electoral result. We were looking for an abuse in order to get that electoral result, which is moving people into districts that were not compact in any sensible way and in a way that basically erased their vote. So imagine being, for instance, in California and being a resident of, I don't know, Sonoma County, and being in a district that went down the middle of the state into Los Angeles. I mean, do you think that's appropriate or proper? No. That's gerrymandering. It was named after Eldridge Gerry, or Gary, I think. Ronald Reagan used to call it gerrymandering. He hated gerrymandering, as he called it. So it's been around for as long as the Republic, virtually. So there's always going to be a certain amount of, when a political party controls the legislature that has control over the apportionment process, which sets the districts, there's always going to be a certain amount of gerrymandering. And in many ways, it's appropriate in the sense that, well, the majority party reflects the votes of the citizens of the state, and so the citizens of the state, you know, are going to get more members of Congress that accord with the majority party currently control the legislature. So I understand the political nature of it. You can't control it completely, but you can mitigate the worst aspects of it in terms of the corruption in a way that violates the rule of law. But it gets worse than just the political side of it. The left has decided, and unfortunately the Supreme Court has interpreted the law to allow political gerrymandering based on the color of your skin. And what happens is they move and essentially segregate voters by race to ensure what is called majority-minority districts in order to ensure that Democrats get elected and left-wing Democrats get elected. And the Constitution, I don't think, allows it. And what the Supreme Court has said was, well, you can do it for gerrymandering, but you can't for redistricting, they called it. But race-conscious decision-making, for instance, in Harvard admissions, is illegal. Well, how does that work? It doesn't. And that's why we filed an amicus brief with the Supreme Court as they're being asked to reconsider this issue. We filed an amicus curiae brief with our friends at the Allied Educational Foundation that often partners with us on amicus curiae briefs. These are friend of court briefs that Judicial Watch files, or attorneys file, with courts to help them or point out specific legal issues in cases that they're considering. Parties obviously are doing the big heavy lifting in the fights. Amicus briefs and friend of court briefs can provide extra oomph on issues one way or the other, or even sometimes just provide factual issues or expert advice or analysis to the courts that the courts value as they consider the cases. So we're essentially asking the Supreme Court, to affirm a lower court ruling that found that using race to set up congressional districts is an abomination. And it was in a Louisiana redistricting fight from just a few years ago. In their amicus brief, it's our amici brief because it's now more than one person filing or more than one group, the court has compared race-based districting to segregation of public parks, buses, and schools, and warned that we should not be carving electorates into racial blocks. There should be no question that the race-based division of citizens for purposes of redistricting is a violation of the Equal Protection Clause, the central purpose of which is to prevent the states from purposefully discriminating between individuals on the basis of race. Racial gerrymandering, like all racial classifications of any sort, cause lasting harm to our society because they reinforce the belief held by too many for too much of our history that individuals should be judged by the color of their skin. We're asking the Supreme Court to put an end to race-based congressional districting. The Biden administration, by the way, jumped into the case at the last minute because they wanted to help continue this monstrosity under law, seeking to maintain the race-based status quo, requiring separating and segregating voters by race for congressional elections. Now, we're hoping the Trump Justice Department does, and we think it should, instead urge the court to restore non-discrimination as the foundation of voting rights again. So the court there's this weird disconnect between court rulings on using race to put people in congressional districts while disallowing race to put people in schools, as a basis to put people in schools. Now, the left will have you believe, well, this helps minorities. Does it help minorities to be put in the equivalent of a congressional ghetto so some Democrats can get elected? Or does it help minorities to have their political power separated among various districts and where they're given more of a political oomph in, let's say, Republican-leading districts? I mean, if a Republican has a district that has no minorities in it, practically speaking, right? Because Democrats have moved them all to ensure they get elected in their districts. Well, why would a Republican pay attention to the views of minority groups in their in terms of their voting issues? Plus, it's illegal. We shouldn't put people in congressional districts on the basis of race. The Constitution prohibits it. You can't be denied equal protection of law on the basis of race. Does it get any simpler than that? Does it? Supreme Court? There are some things only a lawyer could do, or only a judge would allow, with all due respect. And we're hoping the Supreme Court follows Judicial Watch's lead and the lead of many other observers who really want to end the racial strife and division here in the United States that's furthered by encouraging politicians in the states to segregate and separate voters by race into congressional districts. I just can't believe that we even have to make the point to the Supreme Court in this day and age. I mean, we've got a case in Illinois along these lines. By the way, Judicial Watch is a leading civil rights organization. The civil rights organizations of the left have now agreed that racism is okay and discrimination is okay. They've abandoned the field. So it's up to groups like Judicial Watch to take the lead to enforce the traditional understanding and interpretation of the Constitution and civil rights laws. The Constitution says equal protection of the law based on race, despite your race. The left does not believe that. In Evanston, Illinois, they're giving out reparations, supposedly for housing discrimination in the past. And the only, you don't have to prove housing discrimination, but you do have to identify as an African American or black. Whites need not apply. Other races need not apply. It's blatant racism. That's why we filed a federal civil rights lawsuit. And we published this week in an informative educational new video on the reparations fight, which the left is obsessed with pursuing.
The left is obsessed with race-based reparations. Leftists use reparations and other handouts to redistribute wealth to favored groups, purportedly to remedy systemic racism and historical inequalities. The nation's first race-based reparations program was created by the city of Evanston, Illinois. In 2021, the Chicago suburb began earmarking what would become $20 million to pay $25,000 to persons who identify as Black or African American. It began approving cash payments 2 years later. Called the City of Evanston Local Reparations Restorative Housing Program, the scheme purports to remedy housing discrimination in Evanston and explicitly conditions eligibility on race. Applicants need only show that they identify as Black or African American and that they or a Black or African American ancestor lived in Evanston at any time between 1919 and 1969 and were at least 18 years old at the time. Applicants need not prove that they or their ancestors suffered any actual discrimination by Evanston. The children, grandchildren, and even the great-grandchildren of persons who lived in Evanston as many as 106 years ago can receive a payment. Whites, Hispanics, Asians, or anyone identifying as anything other than Black or African American need not apply. Renowned economist Dr. Thomas Sowell describes demands for reparations as a stroke of genius to keep Blacks separated from other Americans and an aggrieved constituency to support Black leaders in politics, organizations, and movements. In 2024, Judicial Watch filed a federal civil rights lawsuit challenging the program on behalf of individuals who would be eligible to receive a $25,000 payment but for their race. The lawsuit argues that the program violates the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. This provision makes treating people differently based on their race presumptively unconstitutional. Judicial Watch filed its lawsuit as a class action because it estimates that there are tens of thousands of persons who, like our clients, would be eligible to participate in the program but for their race. As U.S. Supreme Court Chief Justice John Roberts wrote in a 2007 case, the way to stop discrimination on the basis of race is to stop discriminating based on race. Evanston's program discriminates on the basis of race and is unconstitutional as a result. Judicial Watch's historic lawsuit not only seeks to stop Evanston's unconstitutional program, but also puts other cities, counties, and states considering reparations programs on notice that race-based programs will not go unchallenged in the courts, because no one is above the law.
That was a good little video, huh? I encourage you to share it with your friends and your family, your church, etc. We'll have a link to it separately below. But this is an essential lawsuit. The left has been watching this very carefully. I talked to a reporter from the Boston Globe the other day. What's going on is these other left-wing states and cities are running commissions to figure out if they can do reparations. Well, they've kind of been in a holding pattern. Many observe, not just I'm not saying this, the left is saying this practically speaking to the media, they're kind of waiting to see how this case turns out. Now, hopefully the Biden, well, it's no longer the Biden Justice Department, it's the Trump Justice Department will take some action here as well. But this is important. Do you think that we should begin really destroying the American civic fabric through these reparations programs that are inherently antagonistic and full of pernicious racial favoritism and punishment? I don't. I mean, not only is it awful policy, but it's illegal on its face. And that's why we're in court right now. So racial gerrymandering, no. Reparations, no. DEI, no. All of those policies, CRT, no, are designed to destroy America and our way of life by cleaving a vicious separation between the races. And that's not the American way. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.